Be prepared for uncertainty to persist. The final action on the endangerment finding will likely be challenged in court, and it will take months, if not years, for that litigation to resolve.
Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney-client relationship. This communication may constitute attorney advertising.
Welcome to the Environmental Evolutions Podcast, where we explore the changing landscape of environmental law and policy. My name is Scott Novak, and I work as an associate in Baker Botts' Environmental, Safety, and Incident Response Group. Any views expressed on this podcast are not necessarily the views of Baker Botts. Today, we're diving into two of the most closely watched developments in U.S. climate regulation: the U.S. Environmental Protection Agency's proposal to rescind the agency's 2009 endangerment finding regarding greenhouse gas emissions, along with its proposal to rescind or revise regulations regarding greenhouse gas emissions from fossil fuel-fired power plants. To help us unpack what's in these proposals and what comes next, we have Baker Botts' partner and Clean Air Act specialist, Allison Watkins Mallick, here on this episode. Thank you for joining us, Allison.
Thanks for having me, Scott.
Let's start with the proposal to repeal the 2009 endangerment finding. Allison, for those listeners who aren't familiar, can you provide a summary of what the 2009 endangerment finding is and why it's significant?
Sure. So the endangerment finding was made under Section 202A of the Clean Air Act. And that section requires EPA to regulate air pollutants from new motor vehicles if the agency finds that they cause or contribute to air pollution, which may reasonably be anticipated to endanger public health or welfare. In the endangerment finding in 2009, EPA determined that a mix of 6 greenhouse gases emitted from sources in the atmosphere threatened public health and welfare. EPA reviewed scientific literature and based its determination on observations and projected risks of climate-related impacts associated with those emissions. That includes changes in air quality, increases in temperature, changes in extreme weather events, and increases in food and waterborne pathogens. EPA made the endangerment finding in response to a decision from the Supreme Court, Massachusetts v. EPA, which held that the Clean Air Act's definition of air pollutant permits EPA to regulate greenhouse gases.
On August 1st, EPA published a proposed rule that would repeal the 2009 endangerment finding. Allison, what are the immediate effects that repealing the endangerment finding would have?
The finding itself justifies the regulation of greenhouse gas emissions from new motor vehicles. If the rule is finalized as EPA has proposed it, then the greenhouse gas emission standards for light, medium, and heavy-duty vehicles and heavy-duty engines for model years 2012 and later would immediately be repealed.
What are EPA's stated grounds for the repeal?
EPA provides several bases for its proposed repeal, and a number of these are based on EPA's new interpretation of the text of the Clean Air Act itself. EPA is proposing a narrower approach to regulation of air pollution, focusing on pollution that harms public health or welfare directly through local or regional exposure, rather than looking more broadly at the effects of global climate change as they did back in 2009. EPA is also proposing to limit its consideration to the contribution and resulting impacts from new motor vehicles alone. In the 2009 endangerment finding, in contrast, EPA looked at the climate-related impacts in the U.S. associated with worldwide emissions of greenhouse gases, rather than just the emissions from domestic new motor vehicles. EPA also provides an alternative basis based on its review of the scientific record. EPA points to significant uncertainties in the projected climate-related impacts that underlay the 2009 endangerment finding. EPA is now proposing to conclude that these projections appear unduly pessimistic based on observed trends. EPA also suggests that the 2009 endangerment finding did not appropriately account for potential benefits associated with climate change.
What about the longer-term effects that this could have?
On the regulation side, the endangerment finding serves as a legal trigger for other EPA regulations. So there could be some longer-term knock-on effects from a repeal of the endangerment finding. One example is prevention of significant deterioration permitting, or PSD permitting. PSD permitting must address greenhouse gas emissions from certain new stationary sources or major modifications of existing sources, because the Clean Air Act requires the best available control technology for each pollutant that is subject to regulation under the Clean Air Act. Since endangerment finding established regulations for greenhouse gas emissions from vehicles, then PSD permitting also is required to address those emissions. And of course, if you have a source that has a PSD permit, any Title V operating permit for that source would also need to address greenhouse gas emissions. A repeal of the endangerment finding would eliminate the motor vehicle regulations as a trigger for PSD in Title V.
So, in other words, what we're looking at then with a endangerment finding repeal is potentially no federal greenhouse gas emissions regulations on vehicle tailpipe emissions, and also, by implication, no federal greenhouse gas regulations on stationary sources such as large manufacturing facilities and power plants. Is that correct?
There is a caveat, and that is EPA's regulations of greenhouse gases from certain stationary sources is based on a separate section of the Clean Air Act, Section 111. EPA's made a determination under Section 111 that emissions of greenhouse gases from some stationary source categories have a significant contribution to the endangerment of human health and the environment. That's the basis for the greenhouse gas emission regulations from power plants and also the oil and gas sector, for example. EPA is required to make a separate determination under the Clean Air Act to justify those regulations. Where a source category causes or contributes significantly to air pollution, which may reasonably be anticipated to endanger public health or welfare, then EPA must regulate under Section 111. There are some commenters that have argued that the Section 111 determination, which requires a, quote, significant contribution, is a higher burden that must be met to justify regulation when you compare it to just the contribution that's required to be shown under Section 202A. So this raises a question as to whether any regulations based on Section 111 could survive if EPA finds that there's no contribution to endangerment under Section 202A. In other words, there's an argument that the Section 111 regulations should go away if the endangerment finding is repealed. That exact question has not yet been addressed by the courts.
We've heard some concerns about the potential implications on climate tort lawsuits against companies in the fossil fuel industry that repealing the endangerment finding could have.
There has been preemption in many cases involving climate tort claims against fossil fuel producers and power plants. Several state courts have dismissed these suits based on a preemption or displacement argument. Some observers have discussed the possibility that states may attempt to exercise more authority to regulate greenhouse gases just at a regulatory level, based in part on their argument that there is no longer any federal law preempting the state law in that space.
Relatedly, on June 17th, EPA published its proposal to repeal or revise the greenhouse gas emission standards for fossil fuel-fired power plants. These regulations were promulgated under Clean Air Act Section 111 in both 2015 and 2024. Can you explain EPA's proposal at a high level?
EPA's proposal has two parts, a primary proposal and an alternative proposal. The primary proposal would be a full repeal of all of the greenhouse gas regulations for fossil fuel-fired power plants, both the ones promulgated in 2015 as well as the ones promulgated in 2024. So in the first instance, EPA's proposal would be a complete repeal of all of those regulations. The alternative proposal would amend the regulations on the books. It would leave the 2015 regulations untouched and change the requirements promulgated in 2024. Most notably, it would eliminate the requirements for existing coal-fired EGUs, electric generating units. For newly constructed gas-fired combustion turbines, EPA would eliminate the requirement to install carbon capture and sequestration as a control technology, and instead focus on greenhouse gas emissions requirements that are based on a determination that the best system of emission reduction from those sources is efficient combustion.
And what are EPA's stated grounds for this proposal?
On the primary proposal, the repeal, some of the grounds are similar to what we see in its basis for the repeal of the 2009 endangerment finding. Like in the endangerment finding proposal, EPA looks at the greenhouse gas emissions from the source category. Here we're talking about domestic electric generating units. The EPA concludes that their contribution to global greenhouse gas concentrations is relatively minor and it's declining over time. So based on this observation, EPA is proposing to conclude that there is no significant contribution from these sources to endangerment. Also, like in the endangerment finding, EPA says that the connection between greenhouse gas emissions from the source category is too attenuated to the effects of global climate change, such that there is no necessary causal link to climate change. Finally, EPA looks at the text of Section 111 and concludes that it cannot make the required determination of the best system of emission reductions for greenhouse gas emissions because it cannot identify a system that would meaningfully and cost effectively reduce those emissions. With respect to the alternative proposal, the one that would simply amend the requirements that apply to electric generating units, EPA redoes its assessment of the best system of emission reductions and most notably determined that carbon capture and sequestration cannot be installed on the timeline that EPA previously determined was achievable, and on that grounds eliminates that as a basis for setting standards.
Allison, if you could give one piece of advice to companies affected by these rule changes, what would it be?
Be prepared for uncertainty to persist. The final action on the endangerment finding, as well as the final action on the Section 111 proposal, will likely be challenged in court, and it will take months, if not years, for that litigation to resolve. In the meantime, there could be a request for judicial stays of EPA's new rules. That could have the effect of leaving certain requirements on the books. So the bottom line here is, while we hope that we will move towards some regulatory certainty, it will take us some time to get there.
Thank you so much, Allison, for coming on the podcast and giving us your insights on these significant developments.
Thank you for having me.
Thank you for listening to this Baker Bots podcast. Baker Bots has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on Baker Bots practices, please visit us at bakerbots.com. This presentation is provided by Baker Bots LLP for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.